Imagine this. A crime so horrific it tears a family apart. Then a court decision, well, completely unexpected, focusing on rehabilitation instead of, immediate punishment.
And then the state's highest legal office intervenes, throwing the whole thing into this absolute roller coaster through the courts.
Exactly. This isn't just some sensational story you'd hear about. It's a real, profound legal saga, and it became this stark, almost stinging warning for anyone involved in the justice system, especially those thinking about a career at the bar.
Yeah, it really does sound like something out of a legal drama, doesn't it? The twists, the turns. But it's grounded in the very real human cost of these long legal battles and the weight of the decisions lawyers and judges make.
It pulls back the curtain, doesn't it, on how justice is pursued, how these complex legal ideas are actually applied on the ground, and frankly, the devastating impact when things go wrong.
Definitely. So our mission today really is to take this pile of sources. We've got court judgments, right? From the district court, the CCA, the high court even.
Yep, plus submissions from some top barristers, chronological summaries laying out the timeline, all the raw stuff.
And we're going to unpack it, look at the critical moments, the tricky legal arguments, and the huge personal toll this case took.
We're diving deep into CMB v. Attorney General NSW. And we're really focusing on the lessons baked into this case, especially for you if you're maybe thinking about law, working in it already, or particularly if you're aiming for the bar.
At its heart, the conflict is just harrowing. A father accused of truly awful sexual assault against his young daughter.
Then you have the sentencing judge, faced with these really unusual circumstances, partly because of a specific program and what the offender did within it, who decides to put a lot of weight on rehabilitation.
Leading to a non-custodial sentence.
Right.
Which, understandably, raised a lot of eyebrows.
Big time. Eventually, the state's top legal officer, the Attorney General, saw it as fundamentally wrong, just inadequate given how serious the crimes were.
And here's a key twist early on. The Attorney General steps in after the usual prosecutor, the DPP, had actually decided not to appeal.
Right, which just launched this whole process questioning not just the sentence itself, but also the conduct of the legal teams involved, and even the basic principles of how appeals should work.
Okay, that definitely sets a dramatic stage. Let's get into this incredible cautionary tale, starting, I suppose, where it has to, the devastating foundation of the case.
Act 1. The crime and the path to diversion. The sources, well, they have to lay out the facts clinically, but they're grim. We're talking about sexual assaults committed by a father against his daughter.
Over a 2-year period, wasn't it? Between 2004 and 2006.
Yeah, and she was just 10 to 12 years old at the time. Just a child.
And the sources are quite specific about the severity. Multiple acts involved, described as in the main acts of indecency or cunnilingus.
The breach of trust there is just immense. Within the family unit, the place she should have been safest, it's fundamental to the objective seriousness the courts had to grapple with later.
And what makes it even tougher is that these crimes weren't reported straight away. The victim, who the sources refer to as NB, she carried this for years.
Until 2011, when she was 17. That's when she finally reported it to the police.
And the impact on her. The sources document it meticulously, drawing heavily from her victim impact statement, which must have been incredibly hard to write, let alone have read in court.
Absolutely devastating, life-altering. Her statement just paints this picture of a young life completely thrown off course.
Yeah, the sources mention devastation across, everything. Her schooling, social life, relationships, all severely damaged.
She talked about being constantly preoccupied with it, intrusive thoughts, nightmares, overwhelming guilt and self-blame, which is just tragic, isn't it? Blaming herself for that betrayal.
Heartbreaking. Difficulty concentrating, memory problems affecting her studies, avoiding relationships, both romantic and friendships.
And she explicitly linked that avoidance to a fear of being abused again, of having her trust broken, carrying this secret past, as she put it.
Difficulty experiencing sexual pleasure. Problems forming friendships because of the shame and isolation. It's just awful.
And the psychological toll was immense. Profound depression, multiple suicide attempts, tragically, ongoing thoughts of self-harm, incredibly low self-esteem, confusion about her own identity.
And that continued distress, that self-blame for not stopping it as a child. It's just layers of trauma.
And crucially, for how this case unfolded, the sources note her clear separation from her parents, and specifically, she did not consent to or want her father to enter this pretrial diversion program that became so central later.
Right. She actually doubted the legal system because of what she saw as the initial leniency. Her voice felt unheard, didn't it? in that first sentencing decision.
Which brings us squarely to this program, the pretrial diversion program. The sources explain it was set up under a specific NSW Act from 1985.
And it had particular goals. It was about protecting child victims, yes, but also setting up a health department program for offenders.
Critically, the act itself said that the interests of the child victim were supposed to prevail in how the program operated.
Now, when the relevant regulation, the 2005 regulation was active, the process was quite defined. The DPP, the Director of Public Prosecutions, could refer someone charged with certain offenses for assessment.
A program director would assess if they were suitable. And the act had these, well, pretty unusual provisions for the time.
Section 24, right. That allowed a court to find someone guilty, proceed to conviction, but not sentence them if they agreed to participate in the program and follow the rules.
And Section 31 offered a massive incentive. Successfully complete the program, follow the rules, and no further criminal proceedings would be taken for that specific offense. It was a path to avoid punishment through therapy, essentially.
The program itself, sometimes called the Cedar Cottage program.
Yeah.
It had this specific ethos, didn't it? Participants were expected to really confront what they'd done.
Yeah, face up fully to himself and significant others about all aspects of his abusive actions, is how one source puts it. And they actively encouraged further disclosures of other offending.
As a sign of genuine commitment to change. Which sounds therapeutic, but boy, did it have massive legal consequences here.
So let's trace CMB's path into this system. Just for the first set of charges, initially. After his daughter's report and the police investigation, he was charged with a lot of offenses.
22 initially, back in October 2011.
The DPP then used its discretion, reducing them to 10 representative charges, 5 aggravated sexual assault, 2 attempted aggravated indecent assault, 3 aggravated indecent assault. That's the first set.
Okay. And then the DPP decided to refer him for assessment for the program. That was April 2012.
But there was a snag straight away. No places available in the program. So things proceeded normally for a bit. He was committed for sentence.
But the DPP seemed quite keen on this program path for him, because even though there were potential legal hurdles like adjournment limits or whether the act still applied once he was committed for sentence, they persisted.
Right. The case got sent back to the local court. And when a spot opened up in the program assessment around August 2012, the DPP referred him again.
That really shows how prosecutorial discretion early on can shape everything, even before a judge gets fully involved in sentencing for all matters.
Absolutely. So CMB starts the formal assessment process for that first set of charges. And nobody knew at that point that this very process would uncover more crimes and trigger this extraordinary legal saga.
Act 2. The hidden crimes revealed and a judge's mercy. Okay, this is where a seemingly dry bit of legislative timing becomes absolutely pivotal.
You mean the repeal of the regulation?
Exactly. The Pretrial Diversion of Offenders Regulation 2005, the thing that set out the procedures for referral and assessment, it was repealed on September 1st, 2012.
And the critical effect of that repeal was?
The formal procedures for referring and assessing offenders were gone for charges laid on or after that date, September 1st, 2012.
So the first set of charges against CMB, laid back in 2011, were before the repeal, so the program assessment could continue for those.
Precisely. But any new charges laid after September 1st, 2012 couldn't go down that same referral pathway.
Got it. And the bombshell event happens during the assessment for that first set of charges, right?
Yes, in October 2012. While being assessed for the program, CMB discloses completely new offending against his daughter. Stuff the police didn't know about that she hadn't reported.
This is the second set of offenses the sources talk about.
That's right. The sources say after disclosing to the program staff, he got legal advice and then decided to tell the police himself.
He went to the police on November 2nd, 2012, disclosed 9 initial instances, which were later reduced to 4 counts of aggravated sexual assault for sentencing purposes.
And this disclosure, this is where it gets really complex, legally and ethically. The program encouraged disclosure, sure, as part of rehabilitation.
But the sources strongly suggest, and the courts later discuss this a lot, that there was a big element of self-interest for CMB.
Definitely. It wasn't just pure remorse. He wanted to avoid the consequences if these other serious crimes came out later some other way.
And crucially, he wanted to stay in the program, which, remember, offered a chance to avoid prison and get treatment. That was a clear motivation.
The High Court really dissected this later. Was this disclosure truly assistance to authorities deserving the huge discount he got, or was it mainly self-preservation? That nuance is vital for the Ellis principle.
Okay, so now he's facing these new serious charges, the second set, the 4 aggravated sexual assaults. And he comes up for sentencing before Judge Ellis, DCJ, in the district court. April 4th, 2013.
Important point. This hearing was only for that second set of charges, the ones he disclosed. The first set was still technically on the program pathway via an undertaking.
Right. And that sentencing hearing before Judge Ellis is just ground zero for this whole saga. The sources detail who was there. CMB had his barrister and solicitor.
And the Crown was represented by Mrs. Norris and Mrs. Day from the DPP. Important names to remember.
During the hearing, the victim impact statement was read out, powerfully conveying NB's suffering, the impact on her life, and her explicit view that leniency was not appropriate.
Judge Ellis knew about her suffering. The sources say that. But he seemed really drawn to the program idea, especially given the unusual way these charges came to light through CMB's own disclosure.
He seemed to genuinely believe CMB was trying to do the right thing by disclosing. And he even said this disclosure was the only reason that has led him here for sentencing on these specific 4 charges.
But this is where the crucial errors crept in, according to the later appeal courts. Judge Ellis made some fundamental mistakes in his understanding of the law and the facts.
Like what?
Well, first, he mistakenly thought the second set of charges wouldn't even have been laid if the program's regulation hadn't been repealed. That was wrong. The repeal affected referrals for new charges, not the laying of charges for crimes discovered.
Okay, error 1.
Second, he seemed to think that disclosures made within the program somehow gave participants immunity from prosecution for those disclosed crimes. Also wrong. Program staff had a duty to report crimes to the police.
Big misunderstanding there.
And the biggest one, legally. He misapplied the principles around giving leniency for assisting authorities by confessing to unknown crimes. Section 23 of the Sentencing Act and the R.V. Ellis case, the Ellis discount.
How did he misapply it?
He seemed to give almost total weight to the assistance factor, the disclosure, without properly balancing it against the extreme, objective seriousness of aggravated sexual assault against a child. The balance was skewed.
So, the outcome of that hearing?
Despite the gravity, Judge Ellis imposed non-custodial sentences, 3-year good behavior bonds under Section 9 for all 4 aggravated sexual assault charges. The condition, complete the program.
And he actually said he thought this was the only fair and just outcome, believing it was the same as others who admitted things under the program.
Yes, based on his mistaken understanding of how the program worked and its legal effect.
Now, this brings us to a really critical point, one that got heavily scrutinized later. The role of the lawyers present, especially the Crown Prosecutor.
Mrs. Norris, for the Crown. The sources state she actually told the judge she'd be content with Section 9 bonds, conditioned on program completion.
Content with good behavior bonds for multiple counts of aggravated sexual assault against a child? That's remarkable.
It is. And the sources also note that the Crown's apparent errors, misunderstanding the law, agreeing to what was arguably a manifestly inadequate sentence, weren't picked up or complained about by the defense lawyer at the time.
Which the High Court later described as arguably opportunistic from the defense side? Understandable, maybe, but still noted.
More importantly, the appeal courts, particularly the High Court, later found that the Crown representative, Mrs. Norris, was largely, if not predominantly, responsible for the judge's sentencing approach.
Wow. That speaks volumes about the duty of frankness, doesn't it? Especially for Crown prosecutors.
Absolutely. If a prosecutor thinks a sentence is way too low, they have a duty to tell the judge then and there, respectfully explain why, not just stay quiet and hope to fix it on appeal. This case became a textbook example of why that duty matters.
So, despite this incredibly lenient sentence, there's this brief, weird pause. The DPP, who normally decides on appeals,
decided not to appeal.
Yeah.
On July 17th, 2013, which suggested maybe they accepted it, perhaps because of the complexity or the prosecutor's stance at the hearing.
But that piece doesn't last long.
Not at all. Act 3. The Attorney General intervenes, and the first appeal. This is where things get really unusual politically and legally.
Just 9 days after the DPP said no appeal.
The Attorney General and SW steps in, July 26, 2013, overrides the DPP and decides to appeal the sentence himself.
That is unusual. It's usually the DPP handling appeals.
Exactly. One source even notes how daunting it must have been for the defense barrister, finding themselves arguing not against the usual DPP lawyers, but against the state's top legal officer directly. It immediately raised the stakes, brought a lot of focus onto the case.
So the first appeal hearing is in the NSW Court of Criminal Appeal, the CCA, December 10th, 2013. Who are the judges?
Justices Ward J.A., Harrison J., and R.A. Holm J., a 3-judge panel.
And the legal teams. You mentioned top barrister.
Definitely. For the Attorney General launching the appeal, it was John Egius, SC, leading B.K. Baker, instructed by the Crown Solicitor's Office. Very experienced Crown counsel.
And for CMB, defending the original sentence.
Chris T. Lucas, SC, leading P. Lange, instructed by Legal Aid and SW, also highly regarded. So a real clash of senior counsel.
What were the main arguments? The AG's side must have hammered the inadequacy point.
Absolutely. Their core argument: the sentences were manifestly inadequate, plainly wrong given the objective seriousness. They pointed to the facts, not isolated acts, multiple types of abuse, breach of trust, the terrible harm to the victim.
And they argued Judge Ellis got the law wrong.
Yes, specifically that he misapplied Section 23, the Ellis discount, giving way too much weight to the disclosure without balancing it against the crime's gravity, and failed to properly consider objective seriousness overall.
Okay. And CMB's defense, led by Mr. Lucas, SC.
They argued the sentences, while low, were not unreasonably disproportionate. That's a higher bar than just disproportionate. They said the extraordinary assistance CMB gave by disclosing totally unknown serious crimes justified the big discount Judge Ellis gave him under Section 23.
But they also had a backup argument, right, about discretion.
Yes, the crucial residual discretion argument. They said even if the CCA found some legal error in the sentence, the court should choose not to intervene, not to overturn the bonds.
Why? What factors supported exercising that discretion?
They pointed to the unique way it all happened, the disclosure linked to the program assessment, the delay in appealing, especially after the DPP said no, CMB's supposed rehabilitation progress, and really importantly, the Crown's own conduct at the first hearing, Mrs. Norris's errors and agreement essentially leading the judge into error.
So this residual discretion, it's like a safety valve to prevent unfairness even if a sentence is technically wrong?
Exactly. It's rare, but it allows an appeal court to say, yes, there's an error, but stepping in now would cause such unfairness or oppression, we'll let the original sentence stand.
And there was debate about how double jeopardy distress factored in after a law change.
Right. Section 68A of the relevant act removed the automatic presumption of distress from facing resentencing in a Crown appeal. But the sources clarified that actual distress, the real-world impact on the offender from the appeal process, could still be considered as part of that residual discretion.
So the fight wasn't just, was it wrong, but should we fix it?
Precisely. So the CCA gives its judgment, March 19th, 2014, and the sources call it stinging.
Uh-oh. What did they decide?
They unanimously allow the Attorney General's appeal. They found multiple legal errors in Judge Ellis's sentencing, agreed he misapplied Section 23, didn't weigh objective seriousness enough, other reasoning flaws. They called the sentences erroneously lenient and manifestly inadequate.
Okay, so they found error. What about the residual discretion argument?
This is where the CCA made a move that became hugely contentious later. They essentially decided that once they found appellable error, the burden shifted to CMB to prove why they shouldn't intervene.
They flipped the script. Usually the Crown has to justify intervening, right?
That was the argument later. The CCA considered the factors CMB raised: the history, delay, rehab, Crown conduct, but said he hadn't shown enough reason for them to grant mercy and let the inadequate sentence stand. The need to correct the error won out.
So they decided to intervene. What sentence did they impose?
They ruled that only full-time imprisonment was appropriate for these crimes. They resentenced him to 5 years and 6 months jail with a non-parole period of 3 years.
Wow. From good behavior bonds to over 5 years jail.
A massive jump. And the consequence was immediate. CMB was taken into custody straight from the courtroom that day, March 19th, 2014. Started serving that prison sentence immediately.
Just like that. Shows the massive stakes in these appeals.
Absolutely. From freedom on bonds 1 minute to starting a multi-year prison term the next, because the appeal court disagreed with the first judge.
So Act 4. The battle reaches the highest court. CMB obviously wasn't going to leave it there.
No way. He sought leave to appeal the CCA's decision to the High Court of Australia, the final legal avenue. Getting leave itself is tough, showing the legal significance here.
Who are the legal teams in the High Court? Still big names.
Oh, yes. For CMB, appealing to the High Court, Chris Lucas, SC, was back, this time leading G.A. Bashir, SC, and B.C. Dean, still instructed by Legal Aid NSW.
And for the Attorney General, defending the CCA's decision.
John Aegis, SC, leading B.K. Baker, instructed by the Crown Solicitor's Office. the same lead counsel who won in the CCA.
So what was the core legal fight about in the High Court? It wasn't re-arguing the original sentence, was it?
No, it was about whether the CCA itself had made legal errors in how it handled the appeal. CMB focused on two massive points.
Okay, what was the first one?
The onus for residual discretion. CMB argued the CCA got it fundamentally wrong by putting the burden on him to show why they shouldn't intervene.
He argued the burden should be on the Crown.
Exactly. Citing long-standing cases like Malvaso, Everett, Hernando. In a Crown appeal, the Crown has to justify why intervention is needed and why discretion shouldn't be exercised to leave the sentence alone, despite error. He directly challenged the CCA's script flip.
Makes sense. What was the second main argument?
It was about how the CCA applied Section 23, the Ellis discount, when deciding if the original sentence was manifestly inadequate. CMB argued the CCA used the wrong test.
How so?
They argued the CCA shouldn't just ask, was the sentence disproportionate in our view, but was it unreasonably disproportionate?
Wow.
And crucially, was it open to Judge Ellis, the original judge, to find the sentence wasn't unreasonably disproportionate given the huge assistance CMB provided?
So it's about the standard of review, how much deference the appeal court gives the first judge's assessment of the assistance.
Precisely. A subtle but vital difference in appellate law. Was the original sentence outside the bounds of reasonableness or just lower than the CCA would have imposed?
And the Attorney General's response?
They defended the CCA. Said the original sentences were manifestly inadequate. The CCA applied the law correctly, including Section 23, when resentencing. They pushed back on CMB's view of the onus for residual discretion, arguing Section 68A lessened the weight given to offender distress.
So the High Court hears all this. What's the judgment?
Delivered March 11th, 2015. And it was huge. Unanimous decision. The High Court allowed CMB's appeal.
They agreed with CMB.
Yes. They formally set aside the CCA's orders, the ones imposing the prison sentence. That order was just gone.
So what happened then? Did they impose their own sentence?
No, they remitted it, sent it back down to the CCA to be reheard and decided again, but this time applying the correct legal principles as the High Court had just laid them out.
Okay, but wait. If the High Court set aside the CCA order imposing prison, what did that mean for CMB immediately?
This is the dramatic part. By setting aside the CCA's orders, the High Court effectively, immediately, reinstated the original district court orders, the good behavior bonds.
So even though it had to go back to the CCA for a final decision, the legal basis for his imprisonment vanished.
Instantly. The High Court confirmed the CCA had erred on both key points CMB raised. They made it crystal clear. The onus for residual discretion in a Crown appeal is not on the offender. It stays with the Crown.
And on the Section 23 Ellis discount test,
They clarified that too. The appeal court's job isn't just to substitute its own view. It has to ask if it was reasonably open to the sentencing judge to reach the conclusion they did about the sentence not being unreasonably disproportionate given the assistance. It's a higher threshold for intervention.
so the immediate human consequence for CMB.
Released from prison. He walked free that day, March 11th, 2015, after serving almost exactly 1 year behind bars, March 2014 to March 2015.
A year in jail based solely on a CCA decision that the High Court then found was wrong in law.
Exactly. And this is where the sources talk about the harsh reality, the personal cost and unintended punishment of appeals. Even if you win in the end, you can't just get that year back. It's a powerful, stark reminder of the human toll of the legal process itself.
Wow. Okay, so Act V resolution and reflections. The High Court sends it back to the CCA.
For a remitted hearing, June 12, 2015. And importantly, it goes before a new panel of CCA judges. To get a fresh look, apply the High Court's rulings. Justices Leeming J.A., Simpson J.A., and Hamill J. this time.
Any changes in the legal teams?
Yes, on the Attorney General side, Natalie Adams, S.C., took over as lead counsel from John Kamine, S.C., assisted by B.K. Baker. Chris Lucas, S.C., continued for CMB, assisted by B. Dean. Instructing solicitors remain the same.
So the task for this new CCA panel, redo the appeal but using the High Court's rules.
Basically, yes. They still found that the original sentence did contain appellable error, like Judge Ellis's misunderstanding about Section 24 undertakings. But the main question now, applying the High Court's guidance, was, should they exercise the residual discretion not to intervene and quash those original bonds?
And now they had new stuff to consider, right? Things that happened after the first CCA decision.
Critically important new factors. They had to look at the fact CMB had now spent nearly a year in prison because of the first CCA decision, which was based on legal error.
And his health.
Yes, significant evidence was presented about that. His time in custody and protection, limited access, had apparently worsened existing health problems. Cardiac issues, potential bowel cancer concerns, and eye condition.
The sources mention a heart attack.
Yes, shortly after his release from prison following the high court win. And cancer testing that was planned before he went in got deferred because of the heart attack. So at the time of this final hearing, his health was clearly precarious, impacted by the incarceration. This was uncontroverted evidence.
So a lot more weight on the unfairness side of the residual discretion balance now.
Definitely. So the final CCA judgment comes down, June 25th, 2015. After this incredibly long, twisting journey,
What was the final decision?
the Court of Criminal Appeal dismissed the Attorney General's appeal.
Dismissed it. So the original bonds stood.
Yes. The original district court orders those 3-year good behavior bonds from April 2013 were finally confirmed as the sentence.
And the reasoning? Residual discretion.
Exactly. The panel acknowledged there was error in the original sentence. But applying the High Court's guidance on onus, they were persuaded not to intervene. Why? Because of everything that had happened since.
The time served in prison.
Almost a year, due to appellate error. The documented negative impact on his health, the overall buffeting, as they called it, the uncertainty, the shock of jail, the release, and the fact these consequences, apart from the original crimes, weren't his fault. The injustice of that year in prison was compelling.
Did they mention the Crown's conduct at the first hearing again?
They did. They noted, echoing earlier points, that the Crown rep at first instance was largely responsible for leading the judge into the initial error by not correcting misunderstandings or clearly stating the Crown's position on the inadequacy. That factored into the discretion decision, too.
And the context had changed, too, hadn't it? The program itself was gone by then.
Right. The Cedar Cottage program had been dismantled. So the case's value as guidance for that specific program was limited. The unique circumstances were unlikely to repeat exactly. It became more about the appellate principles.
So CMB v. Attorney General, NSW, really is this singular example, as one source puts it, of an AG's appeal against sentence ultimately failing in NSW after going all the way up and back down.
And failing not because the first sentence was right, but because the process of trying to fix it caused too much other injustice.
Okay, so let's distill this. What does this incredibly complex, dramatic case mean for people listening, especially those thinking about the bar? What are the key lessons here drawn from the sources?
There are some absolutely critical ones. First, prosecutorial discretion and ethics. This case is a huge reaffirmation of Crown duties.
Crown appeals aren't just a second bite at the cherry.
Exactly. Fairness is key. The High Court stressed that appealing a sentence the Crown helped shape or agreed to at first instance can look like a breach of faith.
And that duty of frankness.
Paramount. If a Crown prosecutor thinks a sentence is way off, too low, they need to say so at the time. Explain why. Staying silent and appealing later, especially if your conduct contributed to the error. Heavily criticized here, and it became a factor against the Crown in the end. Young prosecutors need to remember their first duty is to the court in justice.
Okay, lesson 1. Prosecutor ethics. What's next?
Advising clients on voluntary disclosure, the Section 23 Ellis discount. This case does show that confessing to unknown, serious crimes can lead to a very significant sentence discount, even for terrible offenses.
So defense barristers can use this case.
Definitely. To argue for big discounts for clients who self-report crimes that police wouldn't otherwise find, it highlights the public benefit in encouraging that.
But it's not a magic bullet.
No. The case also shows the line, what counts as unreasonably disproportionate leniency is still a gray area. The High Court clarified the test, but applying it is complex. Barristers need to give realistic advice. It's a factor, a big one maybe, but not a guarantee against prison for serious crime.
Got it. Third lesson.
Residual discretion in appeals. Vital to understand where the onus lies, the High Court settled it. It's not on the offender to prove why they deserve mercy.
It's on the Crown to show why intervention is needed and why discretion shouldn't be exercised to let the sentence stand despite error.
Correct. That's fundamental appellate procedure every barrister needs to know inside out.
And the fourth lesson is maybe the most visceral.
The reality and cost of appeals. This case is just such a stark illustration. Appeals take time, they're uncertain, and they can have devastating personal costs for clients.
Like unexpected imprisonment while the appeal plays out.
CMB's year in jail is the ultimate example of that unintended punishment. Barristers must warn clients about this harsh reality. It's not just about legal points. It's about the human impact of the journey.
Fifth lesson. Seems obvious, but clearly isn't always.
Understanding the rules. Technical details matter hugely, like the timing of that regulation repeal and its precise effect. Experienced lawyers got it wrong initially. It underlines the need for super diligent legal analysis. Don't make assumptions.
Good advice. And finally,
Crown conduct matters. The errors by the Crown at first instance didn't just disappear. They echoed through the whole case and were explicitly considered by the final appeal court when deciding on residual discretion. A barrister's actions or inactions at the start can have really long-lasting effects.
so these are direct lessons for practice. But the case had wider ripples too, didn't it?
Yeah, it put the Cedar Cottage program under a huge spotlight, contributing to its shutdown. Some sources suggest the case and the public political reaction to it might have contributed to a broader policy shift away from diversionary programs, especially for sex offenders.
Shows how specific legal cases can intersect with public policy and politics.
Definitely. It reminds us that while we operate in the legal sphere, the cases we argue can spark much bigger conversations about crime, punishment, rehabilitation, and victim welfare.
Okay, so let's try and wrap this up. We followed this incredible journey from district court bonds to CCA imprisonment, high court intervention and release, and back to the CCA finally upholding the original sentence.
But only after the offender served nearly a year in prison due to an overturned appeal ruling.
It just hammers home the complexity, doesn't it? Balancing punishment, rehabilitation, justice principles, and the sheer human cost of the legal process itself. The path isn't always straight.
Not at all. And the process can inflict its own hardships.
Which leaves us with this final thought, especially for you listening, maybe heading into practice. The system aims for the legally correct outcome. But CMB shows the process itself, the appeals, the delays, the uncertainty, the unintended punishment can be a huge part of the story, with real human consequences.
So what responsibility does the system, and maybe more pointedly, what responsibility do you as legal professionals within it have for minimizing that human cost while still chasing justice according to the law?
What does that tricky balance mean for the advice you give, the arguments you make, the decisions you reach? Something definitely worth thinking about long after this deep dive ends.